Well, there was a brief discussion with Your Honor in Chambers last week. I have been in regular communication with Mrs. Stoma about the cases relates to my client. And I'm now, I guess, because although there's more for Your Honor to hear with regard to this matter from the perspective of Mr. Stoma, there really isn't, other than the stipulations that we have in front of you with regard to my client. And at this juncture, I'm going to ask the court, essentially, at the end of the state's case with regard to my client, to dismiss the matter pursuant to State v. Reyes. And to be clear, this stipulation exists for the singular and sole purpose of being heard at this juncture. I know that I am trying a joint case with other counsel. They're certainly not stipulating to anything. I think they're asking to be heard with regard to make sure their position is clear. But it's my position, and I've raised it with Mr. Stoma, that, and Mr. Stoma, whose mandate is to do justice, allowed us, he doesn't have to, but he's allowed us to move forward with this at this juncture, to hear the court's ruling with regard to the proofs against my client. And so I'll do this in whatever order Your Honor wants to do it. Or you want to hear from other counsel first? You want to hear the stipulation? What would you like to do?
All right. Do you have another witness for this afternoon?
I have two other witnesses for this
And
afternoon.
they're waiting outside?
They are, but they'll wait.
Okay. Do you want to hear the stipulation and hear the Reyes argument?
That was my anticipation, Judge. I mean,
Before the other two witnesses?
yeah, the other two witnesses do not offer any testimony with respect to my client. So I can let them go if you want to hear the argument, or I can hold on to them. It's up to you. I just wanted to have them ready here. I do not want to have a repeat of this morning, Your Honor. I want to have witnesses here available, and if they have
Do you
to
think
wait.
this argument is going to take the rest of the afternoon?
No.
I don't think so. I have your
I just want to, oh, I'm sorry.
Go ahead.
No, I just want to be here very briefly on what Your Honor's about to read and it's going to be argued, and then I'm not going to make any other comments with regard to it, because the motion doesn't apply to me. But I just wanted to make it abundantly clear that there's a stipulation in here with regard to Anthony Rucco's testimony. And as I can see, it's several pages from a statement that he gave, and I don't recall the exact date. I think it was September 15th or so, 2015. But there's a stipulation in here, and just to follow up what Mr. Sciarra said, I absolutely positively, on behalf of my client, do not accept at all what Officer Rucco said with regard to my client's involvement in an alleged conversation that occurred. I'm assuming that Mr. Officer Rucco will testify at some point in time. I'm willing to concede that the only truthful statement he made was his name in that statement, and I'm not going to concede it at this point. So I just want the court to be aware that although the court's reviewing this for the purposes of Mr. Sciarra's motion and the state's response to the motion, I do not acquiesce in that testimony at all, and however the court rules on it, I may have an application as to being stricken from the record as far as the case against my client is concerned, unless until the witness testifies in whatever way Your Honor gives to it. So I just wanted to be clear on that I'm not in agreement with that stipulation at all.
This stipulation is as to the state, as represented by the prosecutor, and the defendant, Mr. correct?
Yes.
That's correct, Judge, if I may be heard.
Yeah.
If I just may
Just for purposes of the record. Go ahead.
I certainly adopt Mr. Garrity's statement as it relates to Officer Rucco in totality. I just want Your Honor to understand that the motion that Mr. Sciarra is going to make will impact some of the charges that have been filed against my client. So after he has made his argument, if I could just have a minute or two to speak.
All right.
And the only count my client's involved with is there's a conspiracy where Mike O'Neill is charged as part of a conspiracy with my client. There's no substantive count with regard to my client on those dates. So just to the extent of that conspiracy count, I would join in the motion.
Yes.
Yes, Judge. And the state's position is that in the interest of justice, if Mr. Sciarra is willing to accept that the state is entitled to reasonable inferences that will be drawn from this testimony solely for the purpose of this motion, forward, and the state is entitled to all reasonable inferences that would flow from this testimony for the purposes of the Reyes. At this particular time, the state is willing to move forward with the Reyes motion.
All right, and as long as there's no objection from other counsel, I'll hear the raised motion.
Thank you, Your Honor. Your Honor, the counsel and I have gone back and forth. The stipulation is on the first page. There's an email, essentially, this morning. Counsel and I met to finalize this and emailed each other so that we could print it up in his office. And
Go ahead.
the first aspect of this is that the June 3rd and June 6th police officer testimony is what it is. Meaning, you've heard that testimony. And so that is what's before Your Honor with regard to this. The next stipulation is that Ms. Durango, if called, would testify that a different JCPD motorcycle cop hit her car. O'Neill showed up moments later. Later, Ms. Durango obtained an estimate for $200. Ms. Durango communicated that estimate to Officer O'Neill. There were several phone calls between the parties, including a phone call on June 3rd. And on June 3rd, Michael O'Neill met her and gave her $200 in cash. That's the stipulation with regard to Ms. Durango. With regard to Officer Rucco, the way that this was done was to simply attach.
Do you have an additional copy of this?
I think so. Here.
If you do, if you can provide it to my law clerk, that would be, so we can follow along. See what it is.
Thank you.
Thank you. Go ahead. With regards to
Officer Rucco. And again, Your Honor, if I am unsuccessful here, I will have every opportunity to cross-examine him and deal with that later. But if, I'm stipulating that for the purposes of this motion, there is back and forth, and we start on page 7 of 50, where he's asked, was Captain Ascalise and Lieutenant Chesso later on aware that the woman got an estimate, and he answers yes, and that he was paying for it. And he answers, that's how they repaid O'Neill with DOTs. All right. And he answers, like, that's what I heard. I don't know if he worked the DOTs, so this is what I heard. So I mean, probably to check if he worked them or not. Then Detective Signorelli says, now you heard what? You heard a conversation, or you heard through the grapevine? He says at the top of page 8, well, I heard a conversation between them, you know, from the lieutenant to Mike. It was like, just put in, you know, for two. Basically, I'm going to give you 2 DOTs to make up for the money you paid out of pocket. Question, Lieutenant Chesso said that, answer, yes, but Ascalise was there too. Okay. Sergeant Soshworth then asked, where did the conversation take place? Answer, in the motorcycle squad. Answer, question that I answered, you know where the offices are next to each other, just like in that little, where the mailboxes are. Answer, the main room of the trailer. Answer, the main room. Where? Yeah, the computers are in. Detective Signorelli. Okay, were you the clerk that day? Yes. Okay. AP Lanzat. What do you mean? What did you take? What did you mean? What did you take? I'm going to give you 2 DOTs to me to make up for the money he paid out of pocket, because the DOT I think is like $150, $150 for 4 hours. Detective Signorelli. Was that made clear in a conversation that I'm going to give them to you? You're not going to have to show up, type of deal. How did you know that? Well, they just told him we're going to give you 2 DOTs to make up for the money that you paid out of pocket. So I mean, do you know if he didn't go to those DOT assignments? If I didn't follow him around. It's just, if he did or didn't, but I remember that's what they said to make up for it, That's the stipulation as to Officer Rucco. The further stipulation is that neither Maietti nor Wadeko have, well, it's printed here, I'll just read it. Wadeko and Maietti and Wadeko have no information or evidence to offer regarding O'Neill. No other evidence or information exists in the record that will be presented against O'Neill.
With regards to what was read on this record, is that correct, prosecutor?
That's correct, Judge. And this, again, I'm going to repeat that the entirety of the stipulation is solely for the purpose of this motion.
Yeah, I understand. All right, with that being said, I'll hear.
Your Honor, I pulled State v. Reyes, just go right to the source. And The court said in that seminal case, treating first the motion, this is on page 458, State v. Reyes, let me get that clear, 50 NJ 454. Treating first of the motion at the conclusion of the prosecution's evidence. The broad test for determination of such an application is whether the evidence at that point is sufficient to warrant a conviction of the charge involved. Specifically, the question the trial judge must determine is whether, viewing the state's evidence in its entirety, be that evidence direct or circumstantial, and giving the state the benefit of all its favorable testimony, as well as all the favorable inferences which reasonably could be drawn therefrom, a reasonable jury could find guilt of the charge beyond a reasonable doubt. Now, Your Honor, for the purpose of this motion, although I did not prevail previously, the matter is bifurcated, for lack of a better word, and we're here simply on those charges that deal with my client, Mike O'Neill. And I have those on a piece of paper here. I'd like to just go over exactly the counts that we are addressing. Of course, I did that here. Excuse me a second. It's count one, Your Honor, which is the conspiracy. And the conspiracy goes back to the theft. It's count 4, which alleges theft on June 3rd and 6th. It's count 99, which alleges fraud with regard to the documentation. It's count 100, which alleges official misconduct. Count 101, that alleges the fraud with regard to the documents. Count 102, which alleges official misconduct. And count 104, which alleges official misconduct and a pattern. Your Honor, as a first matter, as I said at opening, the Durango aspect of this case was brought in to try and establish some kind of motive. So we're stipulating that my client did what he was accused of by the prosecutor in his openings. He did a good deed by engaging Mr. Durango, by addressing the fact that there was a theft to a car, the damage was under $500, no police report was required, that he arranged to pay her off so that she would be made whole from the damage resulting from the other motorcycle police officer who hit the car. It was characterized as a good deed, and nothing changes with regard to that here. With regard to that issue, I mean, we had someone who come in and said I did 34 overtimes between the time of the indictment. I think it was all silver, payments at 34. Others said I did lots of them. So all that can be established at that juncture is that my client had $200 out of his own money, and his budget was like $200. Now, the state has, at least for purposes of this stipulation, the testimony of Officer Rucco, who testifies about a discussion that takes place, and that the $200 can be handled by giving him 2 DOTs. But Rucco says, I don't know if he worked them or not. I have no knowledge or information if he worked them. So we're left with the fact that there still has to be proof beyond a reasonable doubt that my client did not work these details. And that is when we get to the issue of the paperwork that's been submitted. Now, if you recall, at openings, Mr. Stoma said the paperwork was the heart of this case. And I said, good luck with that, you're going to have a coroner. At this juncture, the only reasonable inference that can be drawn from the paperwork is that the paperwork from June 3rd and June 6th omits the presence of my client. That is the only reasonable inference that can be drawn. It omits the presence of my client. Period. No one has an independent recollection of those days. The one guy who does have an independent recollection of this, God bless him, he was not involved in anything to do with this day. So all we have is the absence of my client from paperwork on these June 3rd and June 6th patrol logs, and nothing with regard to the supervisor who went around signing the voucher. So all that we have, again, the only reasonable inference that can be drawn from the paperwork is the omission of Mike O'Neill and his name from that. There is nothing further that a reasonable jury, acting reasonable under every favorable inference, could get from the paperwork that we have that in any way establishes anything remotely criminal. First, we have no rules or regulations, no SOPs, no standing orders, nothing that says how the paperwork must be addressed, how the paperwork must be filled out, what the significance of filling out the paperwork in a certain way is. That's first. Secondly, we have nothing. Zero. In fact, we have proof beyond a reasonable doubt that merely putting the name, the address of the intersection on that voucher does not mean you were there, because we have multiple officers, multiple experiences, multiple occurrences where officers are said to be in one place, the voucher says they're another. So no reasonable inference can be made that the existence of O'Neill's voucher and the putting of those two intersections has any bearing on where he's actually supposed to be, what he's actually doing. None whatsoever. And that's the document that allegedly is or that's part of the documentation that's the beating heart, if you will, of the state's case. And so all of the moving parts, the fact that people are moved around multiple times, the fact that sometimes the vouchers are the best record, sometimes the patrol logs are the best record, sometimes neither of those are reliable, the fact that every suggested norm, even on the day in question, June 3rd, we went over it this morning, the roster comes out and it changes hourly. And the roster changed from the reality of what today's witness, Brown, had to say. He said, well, 3 of the names on there weren't even people that I saw. My expectations weren't met because of all the different moving parts. So no reasonable inference can be made. There's nothing that the state can point to say you are affirmatively stating you were at that particular intersection for 4 hours and you did that. I think that's the bill of goods that the Jersey City Internal Affairs Unit sold to the prosecution. There's no other anomalies, and if you say you were out there, you must have been out there for 4 hours, and there's nothing that could be further from the truth at this point. And so given every favorable inference, the fact that the paperwork is wholly unreliable as it relates to what it portends to suggest by way of a fraudulent documentation, by way of theft. Official misconduct requires some unauthorized act. No one's come forward, and no one will against O'Neill, that says that there was some rule or regulation, SOP, or anything else that can be pointed to as to how this was supposed to be done that could be shown to be circumvented. We know that O'Neill was in the motorcycle unit. We know that there are 55 posts, not 52, and we've only seen the state's list that change up to the hour before, where there's 52 officers put out there. For the strict purposes of State v. Reyes, the state has no evidence from which a reasonable inference can be drawn that my client stole, which is the charge, from Jersey City, that my client put in a false document in furtherance of stealing that he was involved in any kind of conspiracy at all with anybody. Zero. And so, Your Honor, at this juncture, and I thank the state for permitting us to move forward at this point because they have shown what they have with regard to Mike O'Neill. Mike O'Neill should be let out of this case. He should go home with his family, Your Honor. He's got more to deal with, but this matter should end for him today. I thank you.
Judge, may I hear just briefly?
I apologize, yes.
Obviously, my comments piggyback to a great extent on Mr. Sciarra's comments because my client is charged in connection with both the June 3rd and June 6th date. And I just point out to Your Honor the specific counts that we're talking about in the indictment. In count 1, my client is charged with Mike O'Neill in connection with the conspiracy involving my client, Kelly Chesler, and Mike O'Neill. My client is also charged in count 4 with third-degree theft by deception as it relates to both the June 3rd and the June 6th vouchers. My client is charged in counts 94 and 95 in connection with the June 3rd date. Count 94 is fourth-degree falsifying a record that would be the voucher, and count 95 being official misconduct in connection with the same voucher. And then finally, Captain Askeles is also charged in counts 96 and 97 in connection with the June 6th voucher. Count 96, he's charged with fourth-degree falsifying a record, that being the voucher. And in count 97, charged with official misconduct in connection with the voucher. I certainly adopt all of the arguments made by Mr. Sciarra, especially those as they relate to the sheer unreliability of the paperwork in this case. It literally does not mean anything, given the testimony that you've heard throughout the course of this case. I think the testimony you just heard today really highlights how meaningless this paperwork is. You heard from Captain Brown today that even when he was not a supervisor on a day, when he was not working any other off-duty jobs that day, he was presented with a voucher, and he signed that voucher even though he didn't supervise the officer that day. And he signed it because, as he testified, he trusted the officer that he worked. Essentially, he stands uncharged for the same conduct that my client has been charged with and stands before you today. Similarly, with Officer Bove. Officer Bove testified that today that at least on 2 occasions, he worked the post, never had a supervisor come by to sign his vouchers, and he submitted them, and he got paid. The vouchers we're talking about here for June 3rd and June 6th could have been submitted unsigned, and Officer O'Neill would have got paid for them because he was standing on a post just like Officer Bove was. There is an additional layer to the state's failure in proofs as it relates to my client. And I stand here before you, Your Honor, with no doubt that the paperwork that the state relies on here does not establish that Mike O'Neill was not at his post on June 3rd and June 6th. In fact, to the contrary, that he is. But even if you were to assume the worst, there's been no proof presented in this case that at the time my client signed the vouchers in question, that he had any knowledge regarding the absence of Officer O'Neill on any post, assuming the very worst. And I submit to you that the evidence is very clear here that Michael O'Neill, in fact, worked those posts. So for those reasons, I would join in the motion to dismiss those counts of the indictment, Your Honor, that I addressed earlier. Thank you.
Thank you, Judge. Yes, Your Honor, the state has agreed to move forward in this fashion because, again, the state open to the fact that the paperwork was going to establish, and the inferences, the reasonable inferences drawn from the paperwork was going to establish, in connection with the other evidence, was going to establish beyond a reasonable doubt that those documents were falsified. Let me just start from the basis of the falsification or tampering with records charge. That is the underpinning of the theft, and it is more specifically the underpinning of the individual falsification charges that apply to both defendant Ascalise and defendant O'Neill on these as it relates to these particular dates. And so the falsifying charge, Your Honor, states a person commits a crime if he falsifies, destroys, removes, conceals any writing of record or utters any writing of record knowing that it contains a false statement or information with the purpose to deceive or injure anyone or to conceal any wrongdoing. So we heard testimony from Thomas Mahoney with respect to how the city was reimbursed and what was required for reimbursement. And what was required were properly executed pay vouchers. Now, Judge the State is not going to chase his tail with respect to the anomalies that were pointed out on the days other than the days at question. The state acknowledges that with this massive amount of paperwork that there were going to be exceptions. There were going to be deviations from what was clearly the expected route of execution of the paperwork. You heard supervisor after supervisor, and specifically Supervisor Donnelly and Supervisor Brown, with respect to these particular dates, that their job was to book in those officers, that their role as a supervisor was to seek out those officers on those corners and sign their pay vouchers. That was the way it was supposed to work. Were there written rules and regulations in place at that time? There were not. Has the off-duty details existed in its form for hundreds of years? I think, Your Honor, certainly it goes back to Officer Silver, who was the ranking officer, who understands that off-duty details have existed for at least 20 to 30 years, and they existed with a procedure in place. That procedure was well known to the supervisors, and from the testimony you've heard with respect to the officers who worked on these individual days, let alone the other days not relevant to these particular dates, that the officers knew what their responsibilities were, was to be there in their traffic vest, directing traffic, waiting for their supervisor to book them into that location. So we have to start, Judge, by looking at the paperwork on the dates in question and what inferences the state is entitled to with respect to those dates. And that's what we're here for, Judge. This is not about the existence of anomalies on other dates. Quite frankly, Judge, it's about the existence of the paperwork and what inferences can be drawn from these dates. On these days, specifically on June 3rd, what we know from the paperwork and from Captain Brown's testimony is that he worked that day. He did a patrol sheet at 16:20. He booked in Giovanni Bo Jr. at SIP 1 and 9, right in the heart of the time period for which Michael O'Neill submitted his pay voucher S8D in evidence. O'Neill's pay voucher, and it's established through the pay records that he was in fact paid for that. The appropriate invoice will establish that O'Neill was paid for that particular day. He submitted a pay voucher saying that he was representing that he was at SIP, working the Skyway Detail 1 and 9 SIP Avenue between 3 and 7. The inferences that can be drawn from the fact that Dave Brown booked in not only both, Judge, but booked in the other officers that were either he expected to see based upon the roster sheet, the master sheet, or who were there at the post that he ultimately supervised. Rodriguez, Bushka, Doyle, Bove, Torrey, Calton, Roskowski, Mateus, and Alvarado, all on his pay voucher, all on his patrol sheet, all with pay voucher signed, all of them by Dave Brown. The only pay voucher not to be signed by the supervisor on that patrol was the voucher for Michael O'Neill, and that was signed by Captain Asplis. So you have the inferences that the state is entitled to, Judge, which would establish proof beyond a reasonable doubt, is that Michael O'Neill was not present on there. When you couple that with the other date, and you couple that with the information that was provided by Officer Rucco that clearly established that there was a reason why Captain Asplis would be involved in and be willing to provide Skyway off-duty details to Mike O'Neill. It's stipulated that there was a conversation, and Your Honor has that conversation. I'm not going to repeat it, but it is stipulated that Officer Rucco heard Lieutenant Chesler in the presence of Captain Asplis indicate that O'Neill was going to get DOTs for money he laid out. Now, what you already know, Your Honor, is that the DOT work was available for anybody at any time. It was uncovered. The evidence has been established through cross-examination and through direct examination that if he wanted to work a DOT detail, he could work a DOT detail. So there wasn't any benefit. He wasn't getting any money back by just allowing him to work a detail. So the inference that the state is entitled to from that conversation is that he was not going to have to work for those details if he was being repaid for money he laid out. That's the inference that the state would ask Your Honor to draw with respect to the conversation regarding Rucco. The state does not contend that Rucco has any direct knowledge. He has never indicated that he has any direct knowledge of whether Michael O'Neill actually worked those. The state acknowledges that, and that's the reason why we're here. He has no information with respect to that. And Rucco, I would assume Mr. Garrigan would accept that aspect of it, where he said, I have no idea whether he worked them. I didn't follow him around. I don't know. However, I did hear this conversation, and this is what I'm telling you. Now, that conversation, Judge, coupled with the absolute deviation from the accepted practices on June the 3rd and June 6th with respect to the paperwork, giving the state the benefit of all the benefit of the reasonable inferences that it's entitled to, Judge, establishes beyond a reasonable doubt that Michael O'Neill falsified those documents with the signature, in conjunction with Captain Asplis' signature that he placed on those documents. It is clear, Judge, that Captain Asplis, and it's always been part of this case from day one, Captain Asplis was the supervisor. Yes, he could and did have the authority to sign overtime sheets. He did not have the authority to sign overtime sheets, or off-duty detail sheets that were not properly worked. When you place those sheets, Judge, next to the series of sheets that exist with respect to those days, and you see that the supervisors on both of those days, Donnelly on the 6th, Brown on the 3rd, signed everybody else's pay voucher and at a specific location, at a location either that they were signed up for in advance on the roster sheet, and then it coordinated with the pay voucher, with the patrol sheets of the supervisors, or jobs that were picked up on the last minute, but still signed by the supervisors who were supposed to be out there. You have to, I believe, Your Honor, yeah, there's a level of divorcing yourself from the common sense, practical application of what this paperwork shows to think that this doesn't amount to proof beyond a reasonable doubt. The state submits that when you look at this and you flip the papers over, you have to ask yourself how and why Captain Asplis signed these sheets and only these sheets with respect to these particular days. That is part of this case, Your Honor. It is the case. It's been the case at this stage. That is what the state opened to it, that it was going to have to rely on the existence of the paperwork and the inferences that can be drawn from the paperwork. The paperwork on these days, Judge, is accurate. It is in conformance with the testimony with respect to the processes and the procedures that were in place, whether it be formally or informally, that existed with respect to how the Skyway detail was supervised, how the officers were booked, and what the responsibilities were, Judge. Every officer that testified here testified that if you were working a shift, you were on the corner and you were directing traffic. The MOU directs that you were on the corner and working a detail. The roster sheets that Your Honor has heard about ad nauseum already with respect to the locations of these were all on an intersection with the purpose of the officer being visible in their reflective vests and out there directing traffic. On these two occasions, Judge, we know that the supervisors were there. We know that because their paperwork says that that's what it is. And although they don't have independent recollections of that, the paperwork is admissible in evidence, and the reasonable inferences that can be drawn from that paperwork is that Supervisor Donnelly was there on the 6th, and he booked in the officer Torrey, who was there on the 6th, and Supervisor Brown was there on the 3rd, and he booked in the officer who was there on the 3rd. Those officers' responsibilities, as they testified to, was to be visible. The supervisors, they were visible enough for the supervisors to book in those officers. Again, Judge, the inference that can be drawn from the fact that they booked in those officers, and yet in the middle of those tours, neither one of them booked in O'Neill. When you combine that with the information that we have with respect to the fact that Mike O'Neill did do a good deed, I have stayed open to the fact that Michael O'Neill, this is a situation where no good deed can go unpunished, because, Judge, the reality is that he did a good deed. He helped out another officer, and he made that woman whole. However, that doesn't excuse the second part of it. It doesn't excuse the idea that he would accept the payment for those for jobs that he didn't work. And the state submits to Your Honor that the paperwork establishes that he did not work on those days.